A very good evening to all of you, those who are visiting, attending this from India. Good morning to the folks attending this from the US and wherever else you are globally, attending this seminar hosted by Grant Thornton Bharat on the US Corporate Transparency Act. The Corporate Transparency Act is a part of the anti-money laundering legislation in the US. It represents a culmination of more than a decade of congressional efforts to implement beneficial ownership reporting for business entities. When it's fully implemented, it will actually create a database of beneficial ownership information that will be available to the FinCEN, the Financial Crimes Enforcement Network, which is an agency of the US Department of Treasury. And the purpose of this database, is to provide resources to crack down on anonymous shell companies, which are the vehicle of choice for money launderers, terrorists, criminals, etc. Prior to this act, the burden of collecting information for beneficial ownership, usually fell on financial institutions, which are required to identify, the beneficial owners through the Bank Secrecy Act. But the Corporate Transparency Act seeks to shift the collection burden, from the financial institutions to actually the reporting entities. Interestingly, just yesterday, some of you may have already come across the news that the federal court in Texas has brought about an injunction which might delay, the implementation of this. And of course, we have with us a very esteemed guest speaker, Melissa Wiley, who will talk to us more about this. Melissa is a partner in the Washington, D.C. office of Lowenstein Sandler LLP, with over 20 years of experience in tax controversy and litigation on a wide range of civil tax matters at both the federal and the state level. She represents clients at all levels on administrative controversy with the IRS, including audits and cases before the IRS Office of Appeals. She has significant experience in handling penalty and international information reporting matters. Her experience includes litigation at the US Tax Court, Court of Federal Claims, and various federal district courts. She also counsels on voluntary disclosures and prior tax noncompliance. Melissa is a frequent speaker at IRS filing requirements, penalties, and enforcement, as well as on ethics and the subject that we're going to hear more about today, the Corporate Transparency Act. With this, I'll hand over to Melissa to take us through what she has in store for us today. Over to you, Melissa.
Great. Thank you so much, Lloyd. If we had had this conversation 2 days ago, it might have been a very different conversation. If we had had this conversation yesterday, it could have been a different conversation. As you noted, there was a case that came down yesterday out of the Eastern District of Texas where a judge held that the Corporate Transparency Act was unlikely to be constitutional, and as a result, he issued a nationwide injunction against the enforcement of the act. There will be plenty to say about that in the news, and plenty to say about that later today. But I do want to kick off with just a brief introduction for those of you who may not be as familiar with the Corporate Transparency Act as others. So Lloyd mentioned that the Corporate Transparency Act is going to be administered by FinCEN, the Financial Crimes Enforcement Network. That is an agency within the U.S. Treasury Department. For those of you who work in tax and may be familiar with the FBAR regime, that is also administered by FinCEN. That is where those filings get made, though FinCEN has given the authority to enforce that law to the IRS. With the Corporate Transparency Act, we don't know if that will still happen, if they will formally delegate the enforcement mechanism to the IRS or another agency. So that part remains to be seen. But just to give you an example of how broad the law is and how many companies it will be affecting, by FinCEN's estimates, there are 32.6 million, very precise, existing reporting companies that will have to file their initial report under the Corporate Transparency Act by the end of this year, so by January 1st, 2025. In addition, there will be 5 million new companies every year that will have to make pardon me, in an initial report as they are formed each year. The question I always get when I make these presentations is, well, how many reports have been filed so far out of those 32.6 million? And the last time we heard updated numbers, it was around 7 million. So roughly 25 million sitting out there waiting to be filed. I can tell you a lot of clients of mine are finally paying attention to this with the end of the year coming. So I know the filing pace has ticked up, but we will see how many we get to by the end of the year. So to jump right into the question that is on everybody's mind, is the Corporate Transparency Act constitutional? The first court that addressed this question was actually earlier this year in March. It was the Northern District of Alabama. They heard a case called the National Small Business United versus Yellen and issued an opinion in March that said they thought that the Corporate Transparency Act was unconstitutional. Now, the thing that distinguishes this case from what happened yesterday is the fact that this case was limited in scope just to the plaintiffs in that case. So just members of the National Small Business Association. And you had to have been a member by March 1st. So you couldn't just join the association and become exempt. And that case was pretty quickly appealed by the federal government. It was appealed to the 11th Circuit in the US, and they heard oral arguments on the appeal in late September. Now, interestingly, we are 2 months later and little more than 2 months later, and we still have not gotten an opinion out of the 11th Circuit. It'll be interesting to see whether now they accelerate that opinion or they let it wait. But that is pending, and we do expect an opinion out of the 11th Circuit relatively soon. At the same time, we've had two recent court cases, one in the District for Oregon, one in the Eastern District for Virginia, that found just the opposite. So these cases, as well as the case that came out yesterday, were in a slightly different posture, which is that the plaintiffs in those cases requested that while the court considered the question of the constitutionality of the Corporate Transparency Act, they would issue a preliminary injunction saying that the government could not enforce the law against them. In the Oregon case and in the Virginia case, the court's analysis looked at whether the plaintiffs were likely to be successful. So essentially, were the plaintiffs correct that the Corporate Transparency Act is likely constitutional? And in both of those cases, the court said no. We think that the law is constitutional, or at least it's likely to be constitutional, so we are not going to issue a preliminary injunction. We will continue with the case. We may think differently by the end of the case, but at this point, we don't think they're likely to be successful, and so we're going to leave things as is. Now, those two cases have been appealed, the Oregon case to the Ninth Circuit and the Virginia case to the Fourth Circuit. Oral arguments have not been heard yet. Those were pretty recent, but we do have now 3 different circuit courts who are considering this issue. In addition to that, there are even more cases that are simmering around in different federal district courts in the US. So we've got one in Ohio, Michigan, Massachusetts, Utah, Texas, Maine, and you can see by the text block at the bottom, this Texas Top Cop Shop versus Garland in the Eastern District of Connecticut. That is the case that ruled yesterday that the Corporate Transparency Act was likely to be unconstitutional and issued a nationwide injunction. Now, one of the really important differences between that opinion and the opinion that came out in March is that opinion did not just limit it to the plaintiffs in that case. In that opinion, the court said it is important that this be nationwide. And so they have said that across the country, they do not think that the Corporate Transparency Act can be enforced. That's obviously throws a wrench into things with today being December 4th and the upcoming deadline in just a few weeks. I can share my thoughts on it, and perhaps this next slide with a map will give you a little bit of context for my thinking. where all the stars are where all the cases are currently pending. We, of course, have the Ninth Circuit over on the left, which is where we have one appeal going. Down in Texas, and the Fifth Circuit is where this case yesterday was decided, and I have no doubt that will be appealed. In the 11th, down in Florida, we've got the case that has been heard by the 11th Circuit, and then, of course, just north of that in the 4th District, we've got another appeal. As those of you who follow U.S. legal matters probably know, one of the things that makes it likely the Supreme Court will take up a case is when there is a circuit split, when circuits in different parts of the country have different things to say and different opinions. I think that very rapidly we are going to see a circuit split here. But of course, what makes things a little even more difficult to predict is that we have a very big change in our administration coming in January. And typically, whether you think the Corporate Transparency Act is constitutional or not, very much depends on your political leanings. So the more conservative politically you are, the more likely you are to think that the law is not constitutional. Of course, we are going to tax significantly more conservatively starting in January. And so it'll be interesting to see a couple of things. One, these courts obviously have judges in them that have been there a long time. Those judges are not going to change with the administration. But the other side of those cases, the government side, the government lawyers are going to change. And whether those government lawyers actually continue to defend the law in circuits like the Ninth Circuit and the Fourth Circuit will remain to be seen. So it is not clear whether these cases will continue to move forward or whether the government will just say, we're not interested in pursuing this because we're just not going to enforce this law. That said, my advice to my clients who are all wondering what they should do in the next 4 weeks is to keep filing. I personally don't see a downside to filing. Before the change in administration, I would have told you that I did not think that these laws were going to be overturned. So, eventually you're going to need to file. Why not just do it now and get it out of the way? I'm not so sure what's going to happen politically anymore. But I do think the easier thing to do is to assume that the law is still in effect and that you do have to comply. For most companies, and I really want to stress this, for most companies, small, simple companies, this is a relatively simple exercise. And it's reporting information that is probably already reported in other places. As Lloyd mentioned, either financial institutions or with the state where the entity was formed, or if you are somehow licensed by the government, you've probably given some or most of this information over. One of the ironies that someone pointed out this morning to me about this Texas case is that the plaintiff, the lead plaintiff, is a gun sales shop. And so they are already highly regulated by the government. The government already knows quite a lot about that business and who works there and who owns it. And so it's not clear how much additional information complying with the Corporate Transparency Act would actually give over. That said, I do think that if companies were going to rely on the Texas injunction and say, look, I'm not going to do anything for the next 4 weeks. I'm going to wait to see how this plays out. I don't think there's going to be any penalty for doing that. There is a federal court in the United States that says you don't have to comply with this. And it would certainly be reasonably understandable if companies said, I relied on that and I did not file until it was sorted out. But again, my advice continues to my clients, which is that while we wait for all the courts to settle this out, I think it makes sense to continue to file. And as those of you who are international and have international practices know, what this law is asking U.S. companies to do is not any different than what companies do all over the world. The United States is late to that party of reporting beneficial ownership. So I think we will get there eventually, I guess, is the bottom line. And I think we may get there sooner rather than later. So you're saying I still need to file. That at least is my advice. When do these filings need to be made? There are three key deadlines. First, the initial report, which is the first report that the entity files. For any entity that was in existence before the beginning of 2024, they have until January 1st of 2025 to file. So again, that's just about 4 weeks now left, and my email inbox certainly shows that there are only 4 weeks left for companies to get their initial reports in, if they existed before 2024. If you've got an entity that was formed this year, in 2024, they have 90 days from the date of formation to file that initial report. Next year, starting in January, that 90 days goes down to 30, and that's where it stays. So 30 days from formation is when that initial report needs to be filed for a corporation or an LLC or any reporting company. The Corporate Transparency Act report is not like a tax return or any other kind of annual filing. It doesn't happen periodically. It happens once, and then it just stays there until and unless something changes. So if any of the information that is reported actually changes, the company name changes, the address of the company changes, the owners of the company change, a new report, an updated report needs to be filed within 30 days. And the same is true for a corrected report. So if a company realizes that something they reported was incorrect, they need to file a corrected report within 30 days of discovering that issue. So what does the Corporate Transparency Act actually require? There are three key concepts that I'll go over that really define what needs to be reported and who needs to report. The first is the concept of a reporting company. So all reporting companies need to file a Corporate Transparency Act report that reports each of their beneficial owners as well as their company applicants. And so we'll go over what each of those things mean. So first, the term reporting company. It's defined in the statute to mean a corporation, a limited liability company, or any other similar entity that is, and this is really the crux of it, that is created by the filing of a document with a Secretary of State or a similar office with a state or an Indian tribe. So typically, say you want to form a Delaware LLC. What's going to happen is that you are going to draw up some paperwork, you are going to file it with the Delaware Secretary of State. They will issue a pretty certificate, and they will say, voila, you now have an LLC, and it is on our books and records. That act of filing that paperwork with Delaware to get that LLC formed, that is what triggers your obligation to file a Corporate Transparency Act report. Now contrast that with something like a general partnership where some partners get together, they draw up a contract, they all sign the contract, and now they have a partnership. Nothing is filed with the state, nothing is filed with the government to create that partnership. There is no filing requirement for that partnership. That is also the same for most trusts, right? For most trusts, you simply draw up a trust agreement, and the people who are related to that trust, the trustee, the grantor, everybody signs it, and now we have a trust. Ordinarily, there's no need to tell the state to file anything with the state to make that trust come into being. So again, that is not a reporting company, not something that needs to file a report under this law. For foreign companies, there's kind of an analogous rule, which is that if you are formed in a foreign country and you formally register to do business in a U.S. state, that act of formally registering to do business is what triggers your Corporate Transparency Act reporting requirement. So I get the question all the time, what if I have a foreign company? Say I formed an entity in the Caymans and it operates in New York, but it never actually registered to do business in New York. What then? Say they even should have registered to do business. And my answer to that is always, you may have an issue with New York State about not registering, but you do not have to file under the Corporate Transparency Act. The Corporate Transparency Act only kicks in, only imposes a filing requirement if you engage in that formal act of registering to do business with the state. So if you remember nothing else about what a reporting company is, it's that trigger of when a report needs to be filed, and that is very specifically when something gets filed with the government. Now, there are many exemptions, right? We started with a very broad definition. Pardon me. We started with a very broad definition of who has to file. There are 23 categories of exemptions of entities that do not have to file. And what you'll see is that many of these are types of companies, industries that are already very highly regulated within the US. And the government probably already has the information that they need about those entities. So think about things like broker dealers, banks, insurance companies, utilities, tax exempt entities in the US have to file significant disclosures with the IRS. Any of those categories of companies do not need to file, even if they otherwise would be reporting companies. One of the exemptions that's relied on very heavily is this last bullet on this slide, the subsidiaries of certain of the above name exempt entities. So most of these, if you have say a bank that has multiple wholly owned subsidiaries, the bank is going to be exempt from reporting by virtue of the fact that it is a federally regulated bank. And all of its wholly owned subsidiaries are then also going to be exempt from filing because they are wholly owned 100% subsidiaries of an exempt entity. I tell people all the time, if you're going to rely on one of these exemptions, make sure you go into the regulations and very specifically read what is exempted and what is not, because there's very specific language around each of these. But the subsidiary exemption in particular can be very useful in getting companies out of this reporting regime. Now, there are two others that I didn't have on the slide before because they require a little bit of explanation. The first exemption is for dormant companies. So a company that essentially has been sitting on the shelf for at least 4 or 5 years. It was in existence before January 1st, 2020, not engaged in active business. Importantly, it has no foreign ownership. And in the previous year, it has not had any ownership changes. It has not sent or received more than $1,000, and it does not hold any assets. So essentially, this entity has existed on a shelf somewhere. It's not being used, and the only thing it does is it probably pays its $300 filing fee every year with the state just to keep it alive. I have lots of clients that have these entities either left over from a transaction that was going to happen but didn't exist, or waiting for a transaction that is going to exist. And my advice here is, if you want to rely on this, make sure that you can tick all of those requirements. But even more importantly, if you think you might use the entity, why not just file for it now? I think it's very easy to tip in and out of this exemption. And of course, if a company is exempt and then it loses its exemption, it has to file. So one thing that I have recommended to clients is, if you have one of these companies, you probably should have gotten rid of it by the end of last year. But if you didn't, maybe you just want to file for it anyway, so that you don't have to worry about monitoring each of these requirements. The second one, which is also relied on by a lot of clients of mine, is the large operating company exemption. And that exempts from filing any company that meets all three of these criteria. So they must employ more than 20 full-time employees in the United States. They must have filed a federal tax return for the prior year with more than $5 million in gross receipts or sales. And if they're included on a consolidated return, they can count that whatever is reported on the consolidated return. Importantly, however, they cannot aggregate the employees over a consolidated group. So the entity itself specifically has to have more than 20 full-time employees. And the last requirement is that the entity has an operating presence at a physical office in the US. That has lots of qualifications on it, including the fact that You can't share the physical office with any entity that you are not affiliated with. So you could have various subsidiaries sharing a physical office, and that would count. But if you had kind of a shared workspace, or if the company is operating out of someone's home, those things are not going to count for purposes of this exemption. And again, if you're going to rely on this exemption, it really makes sense to spend some time with the exact words of the regulation to make sure that you're satisfying those. So now we know what a reporting company is. The second thing to understand is, who are these beneficial owners that we are reporting, right? So the beneficial owners, I like to think of as falling into one of two buckets, and I'll go through the second one first. The most obvious definition of who a beneficial owner of an entity is someone who controls at least 25% of the ownership interests of the entity. So 25% or more owner. Which obviously begs the question of, what if you have a company that is owned equally by 5 people? All of them have 20%. Nobody has at least 25%. Who are you going to report as a beneficial owner? And the answer is that second group. So anyone who exercises substantial control over the entity is also considered a beneficial owner for purposes of this law. I get the question often, these substantial control people, do they have to own any interest in the company? And the answer to that is actually no. So unfortunately, the definition is confusing in that it calls people owners who aren't actually owners. People with substantial control may own part of the company and they may not. And we'll take a look at what the definition of those people, what that includes. But first, before we get to that, you'll notice that at the top I have underlined in bold, directly or indirectly, which is from the statute. So you can be a beneficial owner either directly, you just own shares in a corporation, or you own a membership interest in an LLC, or you can own it through a variety of means, and this is straight from the statute. Including, do you have board representation? Do you have the ownership or control of the voting power of the company? Do you have certain rights associated with a financing agreement? Do you have control over an intermediary entity that has control over the reporting company? And the definitions keep getting more and more vague and attenuated until you get finally to the bottom, where the definition essentially is no definition at all. So you could own something through any other type of contract or arrangement, understanding, relationship, or otherwise. So quite broad. When I've talked to folks at FinCEN about this and said, these definitions don't make it easy for people to comply. They're very, very broad. The answer I got was, well, we need to make them broad so we can catch the bad actors who are trying to find loopholes. Which my answer to that is always that the bad actors aren't actually going to file. And in the meantime, what you're left with is clients like mine who are trying to comply, who can't make their way through these regulations because they're so broad and vague. But that's where we are. That is what the law says, so do keep that in mind. So I promised to tell you who these substantial control people are. Again, remember, they can be in control either directly or indirectly. And there are 4 basic categories. The first one is the most prescriptive, right? So you are going to report as a beneficial owner anyone who is a senior officer of the company. And that very specifically means the president, the CFO, the general counsel, the chief executive officer, the chief operating officer, or anyone who holds that kind of role, even if they don't have that specific title. So for instance, with an LLC, oftentimes I don't see these specific titles, but you've got an LLC manager. And so that person usually is the person who is in control, would operate like a president, like a CEO, and that's who ends up getting reported. Substantial control people also include anyone who has the authority to appoint or remove any of those people we just talked about, or a majority of the board of directors. And now it gets even more vague. It includes anyone who has direction, determination, or substantial influence over important decisions of the reporting company, and some examples that the regulations give of that are whether or not to merge the company or shut the company down, change its product line, move its geography, those sorts of major decisions. And then the very last definition kind of eats up everything else. It just says, well, and anybody else who has any other form of substantial control over the reporting company, which again is one of those just really overly broad and not at all helpful definitions that I guess are supposed to close any loopholes, but make it really hard for companies that want to comply to try to figure out what that means for them. Who are these substantial control people? And just when you thought ownership interests must be easier, it's actually a little more complicated than it seems as well. Recall that the ownership interest can be direct or indirect, so it can mean that you own something through a trust or some kind of joint ownership. And it doesn't just mean stock or capital or profits interests. It can also be voting interests. So I had a question yesterday. Someone said, look, I've got somebody who only has 25% of the company or 20% of the company, but they hold 50% of the votes on the board. I said, well, that person is a beneficial owner then and needs to be reported because of how broadly ownership is defined. It also includes any kind of, say, convertible debt. So somebody who holds a convertible note can convert that note in for ownership. If exercising that convertible debt or any other kind of option for that matter would make that person a 25% or more owner, you do have to include them, even if they have not exercised. So that gets a little bit difficult in figuring out who all those people might be. And then specifically for trusts, and this is something that I see a lot in my practice where we've got clients who own family businesses through trusts. A beneficial owner has to be a person. I can't list XYZ Trust as the owner of an entity. And so what FinCEN has said is that for trusts, the beneficial owner is likely going to be, and this is a non-exhaustive list, the trustee or any other person who has the ability to dispose of trust assets. So in the documents that I review, that could include an investment advisor. Sometimes there's some sort of business advisor or business trustee who has the ability to say where the trust will invest. That person probably is a beneficial owner. Beneficiaries who are the only beneficiary and essentially have the right to demand a distribution of the assets, those folks are also going to be included, as well as if you've got a revocable trust, the grantor or settler who has that right to revoke is going to be a beneficial owner as well. So what you quickly realize in looking through these definitions is in the easy situations, reporting is easy. In the difficult ones, it is not. So you really need to spend some time with the LLC agreements, with trust agreements, articles of incorporation to figure out who all these people are who need to be reported. The other people that have to be reported are applicants, or sometimes they are called company applicants. What that means is essentially the following. In my example of somebody who goes to Delaware and files for an LLC, the person that actually gives over to Delaware, either online or in person, that document requesting that the entity be formed, that person is the first company applicant. If that person was not the one whose idea it was, if that person was, say, just a paralegal, or maybe it was a corporate formation company like CSC or CT Corp, the other person you are going to report is the person who told that person to do it, the person who was primarily responsible for directing or controlling that filing. So a lot of times this is going to be the advisor, right? This is going to be either the lawyer or the accountant or the other type of business advisor who said you should form this LLC. You're going to have to report those folks as well. There may be more than one person who falls into that second category. The form only requires you to report two. So it's always going to be that person who makes the actual filing, and it is going to be a person who was primarily responsible for directing that. So what actually needs to be filed now that we've identified these people? For the company itself, it's pretty simple. Their full legal name and any trade names or doing business as names, the address of their principal place of business, where it was formed, and the EIN if it's domestic. If you've got something like a single member LLC that's disregarded, that doesn't have its own EIN, it can either report the social security number of the individual on whose return its activities are reported, or if it's disregarded into another entity, it can report that entity's EIN as well, but it does need to report some type of IRS TIN. And for a foreign reporting company, it's very similar. It's going to be the address of their primary location in the US. And if they don't have an EIN, they don't have an IRS taxpayer identification number, they can report the foreign number. And that is what the form looks like. And so you can see it tries to be helpful. It has in yellow where you have to enter things. And then as you go through, it's interactive. So for instance, if you look at number 10, if you enter a state of formation, it then grays out tribal jurisdiction of formation. So it does try to help you out a little bit as you're going through. Here's the good stuff. What needs to be reported for the individuals, these beneficial owners we've identified. And it's their full legal name, their date of birth, their home address. And then you actually have to provide a copy of either a non-expired US passport, a non-expired driver's license, a non-expired US identification document, some sort of state ID. Or if you've got someone who doesn't have any one of those things, they're a foreign individual, for instance, they can use a non-expired foreign passport. The alternative to providing this information every time somebody has to be listed on a report is to have them obtain something called a FinCEN ID. And what that is you go into FinCEN's website and you basically provide all of that above information directly to FinCEN. FinCEN then gives you a 12-digit number, and you can use that to report on any of the reports that you need to be listed on. So here's an example of what that form looks like for the beneficial owners, and you can see line 36. If you put in a FinCEN ID for somebody, everything else gets grayed out, you're done, you move on. If the person does not have a FinCEN ID, you're going to have to go in and enter all of that information in yellow. And it's very similar for these company applicants that we talked about, except that they may use their business address instead of their home address. If filing documents like this in the course of their business is what they do for a living, they can use their business address. Importantly, the company applicants, and this will become less relevant very soon, but company applicants don't need to be reported for any of the existing the companies that were in existence before 2024, because that would mean we were making companies that were formed in 1950 go back and figure out who actually filed the documents, and nobody wanted to do that. But those folks do have to be reported for any entities that are formed January 1st, 24 or later. And that is what that reporting form looks like. Very similar to the beneficial owners. So the part that everybody, I leave it close to last, the part that everybody wants to hear, what actually are the penalties for violations. And if you remember nothing else about the penalty regime, it's what I have there in red, I'm not very subtle, is that the penalties are only for willful behavior. What does that mean? FinCEN has addressed this publicly in comments and said, look, we're not going to impose penalties on somebody who simply did not know this law existed. We're not going to impose penalties on somebody who had a good faith belief that one of the exemptions applied to them. We're not going to impose penalties on somebody who tried to get it right but made a footfall. Those are not willful failures. What we're looking for, and the only thing that is penalized under this regime, are people who purposefully either did not file or provided false information. And for those people, there's two regimes of penalties. One is a per day penalty of $500. That is indexed for inflation, so it's currently actually $591 because the law was passed in 2021. And there's a criminal aspect as well, which is that you can be fined for up to $10,000 and 2 years in prison. You know, repeatedly when FinCEN has talked about that, and I think particularly in light of the cases that we discussed at the beginning, I don't think you're going to see a lot of these penalties, except in the absolute worst cases, right? People who were purposefully hiding assets and looked at this regime and just said, we're not going to come into compliance. We're not going to participate in this because we're doing something else that is illegal or improper. So while the penalties can be stiff, I think FinCEN will impose them sparingly, and I certainly think that in light of the court cases we talked about and the change of administration, that is what we're going to see going forward. Lastly, I just want to touch on, you know, who can access this database. We've now got this database of all of this information about who owns and controls U.S. entities. Who gets to look at that data? And there are essentially three buckets of people who can gain access to the information in this database. One are U.S. federal agencies that are engaged in national security, intelligence, or law enforcement activity. So the FBI can ask FinCEN, you know, can we get the Corporate Transparency Act data for the following people or the following entities. Similar rule for state or local or tribal law enforcement agencies. If they are using it in a criminal or civil investigation, the difference there is that it needs to be authorized by a local court that says, yes, you can go get information from that database. But the request still has to be made of FinCEN even once you've got that court authorization. And then lastly are foreign law enforcement agencies. And essentially what happens here is that the foreign agency will ask through their sister agency in the US. So the Indian version of the FBI may ask the US FBI, you know, we're trying to track something down. Can you give us information about this person or these entities? And that request to FinCEN would be made by the US agency. Importantly, FinCEN can say no to any of these requests for any good cause. They can say, we don't think that's a good enough reason to access this information. But there's one important category that does not apply to, and that is tax purposes. One of the stated requirements or the stated purposes of the Corporate Transparency Act was to crack down on tax evasion. And so within the law, there is a separate provision for access to the database for employees and officers of the Department of Treasury, which of course includes FinCEN, but also the IRS. They can only use that information for tax administration purposes, but as you'll see, that definition is quite broad. It basically includes anything that the IRS does. So assessing taxes, collecting taxes, enforcement, you know, in your audits, in litigation. For any of those tax administration purposes, the IRS can access this data. So it will be interesting to see how they use that. And how they feed it into their existing information and technology. One last note before we turn it over for questions. What we've talked about so far has been the federal version of the Corporate Transparency Act. A number of states have also considered their own version, and New York actually enacted one. It is going to be effective January 1st of 2026. And what it requires is that all LLCs, so it's not as broad, it's not all companies, it's just LLCs, formed or authorized to do business in New York have to file a very similar report. We don't have that report yet. They still have a year to come up with it, but the law applies basically the same framework as the Corporate Transparency Act. One important, well, I guess there are two important differences. One is that the New York law is actually an annual requirement, so you have to file annually. And if you are relying on an exemption not to file, you actually have to affirmatively claim that exemption with the state and say, we're exempt. Whereas on the federal side, you do not have to do that. People ask me like, why would New York bother to do that? They have access to the Corporate Transparency Act data. And I think it's just, they don't want to have to go ask for it from the federal government if they can just get it and have it in-house. And why is it only limited to LLCs? Well, for corporations, New York specifically already requires quite a lot of information when you form a corporation and when you report annually. So I guess they felt like they already had enough information there. But the takeaway from this is that, there are other states who have been considering similar acts like this. None of them have passed, but you may see other states do something similar as well in the future. So Lloyd, I'm happy to turn it over for questions.
Thanks, Melissa. I think we had a very insightful, 45 minutes hearing from you, and I'm sure the audience would have had some of their queries answered, but there are quite a few questions in the Q&A box. I'll probably pull up some that we can cover together.
Yeah, sure.
The first question we have is, so you do believe that if we don't want to file for confidentiality reasons, we can wait to file it as you don't believe the penalties will apply as long as we are relying on the injunction from the Texas court that it is unconstitutional. Basically, we can wait till there is clarity
Yeah.
from the courts. Yeah.
Yeah, I mean, I think it is. I think it is reasonable to look at that opinion, and the court is very clear that the injunction that it's issuing is not limited at all, that it is a nationwide injunction. And so I do think that if you want to rely on that court opinion, you certainly can do so. I can't imagine there being any kind of penalties for relying on that. It's a federal court decision, and it very clearly says it's applying a nationwide injunction against the enforcement of the Corporate Transparency Act. Legally, I don't think that the Texas court is right, but and I think you'll end up needing to file at some point anyway. But if for confidentiality reasons, you don't want to, I think that you can very validly rely on that decision.
Okay, thanks, Melissa. Another one, perhaps a simple one. What happens if my entity is a foreign company, but is listed on the New York Stock Exchange? So does it qualify, or are there any exemptions?
Yeah, so publicly traded securities issuers are one of the exemptions. So if it's traded on the New York Stock Exchange, it should fall under that exemption.
Okay, perfect. And does the company need to file this form if the beneficial owner is not an individual, but an entity that is listed on the stock exchange? There's no individual holding shares in the company.
Oh, so yeah, so the beneficial owners always have to be individuals. So if you keep going up and you hit an entity, you have to look through that entity to figure out, who the beneficial owners of that entity are. And remember that it's not just ownership, it's also substantial control. That said, if you have an entity that is wholly owned by a publicly traded company, that entity is likely going to be able to rely on the subsidiary exemption. So take a look closely at that. Because that subsidiary entity, because it is if it is wholly owned by an exempt entity, should be able to claim an exemption as well. However, there is also, and let's see if I can find the slide. Show you one thing. Okay, here we go. If the ownership of an entity is by another exempt entity, so say you've got a company that is owned by a tax exempt entity and a publicly traded entity, you can actually stop there. That is one of the exceptions to the rules that you always have to go up to a person. And what you would do is on line 37 here, you could see it says exempt entity. You would click on that, just provide on line 38 what the name of that exempt entity is, and you can stop there.
Okay, perfect. I think that's helpful. I think a very similar question in the India-US context. So let's say we have a US company which is a wholly owned sub of an Indian company, maybe listed in India, may not be listed in India. So whether the beneficial owners of the Indian company will have to be disclosed?
Yes, they would. So if you've got a US company and its ownership is entirely by another Indian company, um, you would have to keep going up and looking for who those beneficial owners are.
Okay. What about corporate trustees? So who do we report if we have a corporate trustee? Who's the beneficial
Yeah.
owner?
So the corporate trustees have been taking a couple of different approaches, and I always tell people just reach out to whoever your corporate trustee is and ask them, have that conversation. Many of them in the United States are themselves subsidiaries of banks. So they are exempt from reporting, and what happens is we end up reporting them on this page that I've got up now, clicking on line 37 to say that the trustee is an exempt entity, and then just putting in, for instance, Northern Trust Company of Delaware, because we know that they're exempt from reporting. But then you've got corporate trustees that are not exempt from reporting, and they've been taking different tactics. Sometimes they will say, well, we will give you the FinCEN identifier of the individual trust officer who manages this account, right? That individual person. Some of them are choosing to give the FinCEN identifier for like the head of the trust company or the head of the trust department. But really, it's a conversation that you need to have with your corporate trustee about how they're handling it and what information they're willing to give you.
Okay, perfect. Another interesting question, Melissa, regarding the large company exception. One of the prongs is the employee count.
Yeah.
Is this at a certain point in time? We have a question that in some months we have more than 20 employees, some months we have less than 20
Yeah.
employees. You got to average those out, or
This is a great question. And this is why I tell people to beware of this exemption, right? It is a constant monitoring exercise. So if you've got 21 employees in March and then in April you dip down to 19, you now have to report under the Corporate Transparency Act because the exemption no longer applies to you. And then if you suddenly go back up to 24, you can file an updated report that says now we're exempt again. And then if you dip down again to 18, within 30 days, you have to go in and tell them, sorry, we're not exempt again. And so, what I tell clients that are kind of around those numbers, either close to that 20 employee number or close to that 5 million number, is you probably just want to report and forget it. There is no penalty for over-reporting for not claiming an exemption that you're entitled to. And that is probably much easier than having to constantly go in and say, oh, we've got 20 now. No, today we don't have 20. Oh, we have 20 again this month. But it is you have to maintain it constantly. And the minute that you get below the threshold, you've got 30 days to go in and update and say, sorry, we don't meet the exemption anymore.
okay, okay. I think just one last question we'll probably take. What about partnerships which are filing returns in certain states only because they have a resident partner, right? So that is that considered filing with the state, because that's not a Secretary of State filing, that's an income
It
tax.
is not. So very specifically, the only thing that triggers a foreign company for having to file under the Corporate Transparency Act is if they go to a state and they register to do business there. So filing a tax return does not count. If you have to file some other regulatory paperwork with a state, that does not count. The thing that brings you within the Corporate Transparency Act regime is filing to do business, registering to do business in that state very specifically, and it's usually done with the state's Secretary of State or a similar office. So everything else, people ask with trusts, sometimes trusts will kind of register with a state or register or make a filing with a court to get the court's jurisdiction, the state's jurisdiction over the trust. That does not bring you into the Corporate Transparency Act regime at all. It is very specifically just registering to do business with the Secretary of State that gets you into this regime.
Okay. Thanks, Melissa. I think this was very insightful. I know we have a few more questions to the audience. We'll revert to those questions in due course. We have your contact details, and we'll make sure that we get back to you on some of those questions. But thank you so much for giving your time and attending this webinar today with us. Hopefully, you go home a lot more enlightened with respect to the Corporate Transparency Act. Whether you choose to file now or wait till the courts fight it out is, of course, your prerogative. But as Melissa and I would say, if you we'd rather file early than and have a peaceful Christmas, but it's up to you. So thanks, Melissa, for joining us today, and you have a great day. Thank you, everyone. Thank you.
Absolutely. Have a good day.
Thank you.